Hello, Dr. Michael Arnhem here again, and Bernard the Barrister Bear. Hello! And this video is called Rights Against Rights. Rights versus Rights. Part 1. Because practically every case involving human rights actually has rights on both sides. This is not always realized because, unfortunately, there are even some judges who seem to think that if one of the parties is claiming rights under the Human Rights Act or the European Convention on Human Rights, then that party should be favored. Well, that doesn't follow at all. And I'm glad to say most judges don't take that position at all. Most do not. And of course, that results in a balancing act. It's got to be realized that there is a Human Rights Act now, and there's the European Convention on Human Rights, which is incorporated into the Human Rights Act. But those rights by no means exhaust the rights that you and every other law-abiding citizen, well, and even non-law-abiding citizens, enjoy. Do you have the right to call fire in a crowded cinema or theatre when there is no fire? This has been endlessly discussed. The most famous discussion of it goes back over 100 years to the judgment of Oliver Wendell Holmes, who felt that you didn't really have that right. And the test was whether there was a clear and present danger to others in your exercising your right of freedom of speech. Why can't you exercise your right? Bernard is right. Why shouldn't you be able to exercise your right by calling out fire when there's no fire? Isn't that just simply an exercise in free speech? And unfortunately, as with so much of our law, and even in America, because of course Oliver Wendell Holmes Jr. was an American judge, the law isn't clear. It really should be, especially in an area like this, but it's not. And of course that's not entirely a hypothetical case of people calling out fire. There have been cases like that, and the problem there is that when that happens, of course, the audience makes a beeline for the exits, and in the process, there's a good chance that people will be trampled to death, and that has happened on occasion. That has actually happened. Obviously, if there really is a fire, then it's important to have fire exits and so on, and hopefully people would not be trampled to death. But if there is no fire, even with adequate exits, there is a danger of that. This whole question of the right of freedom of speech is particularly relevant in regard to demonstrations and protests. And of course, you can immediately see the clash there between the right of the protesters and the rights of the citizens whose actions, activities are curtailed or even stopped or prevented by the demonstrations. A new law has just been passed in Britain in regard to that, called the Police, Crime, Sentencing and Courts Act 2022, which was passed on the 28th of April 2022. And it is too early to say at the time of this recording, which is in November 2022, what effect that will have remains to be seen. But there is a recent case, which is a yo-yo case, unfortunately, like so many, involving this issue, of course, prior to the new law, though. It's a case called Director of Public Prosecutions and Ziegler, Director of Public Prosecutions against Ziegler, 2021. Now, by a yo-yo case, which I have discussed in previous videos as well, we mean a case where there is one outcome, one party wins at first instance, on appeal that party loses, and on a further appeal that party wins again. This was such a case. There were 4 people who blocked one side of the road going to the ECHR Centre in London, which really stands for Exhibition Centre, because they objected to the arms trade, and what they were doing was protesting against the biennial arms fair, which is always held in the ECHR Centre, which is in East London. This was in 2017. These protesters were not satisfied just to stand with placards or anything like that. No, they actually laid down in the road, preventing people from actually attending the fair, the conference. And they lay down in the middle of one side of the dual carriageway, and they attached themselves to metal lock boxes, which were very difficult to detach, from which it was difficult to detach them. It took the police, it is estimated, an hour and a half, 90 minutes, to clear that road. And these 4 were arrested. There were another 4 who blocked the road in a different way by hanging from above and so on. But the case was about these 4. So we're really only talking about 4 plus 4, maximum of 8 demonstrators. who were charged under the section 137 of the Highways Act 1980, which says, if a person without lawful authority or excuse in any way willfully obstructs the free passage along a highway, he is guilty of an offense and liable to a fine not exceeding level 3 on the standard scale. But without lawful authority or excuse willfully obstructs the free passage. Well, in this case, clearly it was willful, in other words, intentional, but the question arose over the other words, without lawful authority or excuse. Well, obviously, they didn't have lawful authority to do that. So the whole case turned on lawful excuse. Did they have a lawful excuse to do this, to block the highway? Article 10? Bernard correctly says, of course, they could invoke Article 10 of the European Convention on Human Rights, which is about free speech. Is this an exercise of free speech? So here we have a clash of the laws. On the one hand, we have the 1980 law, Highways Act, which says you can't block a highway willfully without lawful excuse, and then Article 10 possibly giving you that lawful excuse, freedom of speech. But what about the rights of others? Because in blocking that highway, you were also preventing other people from exercising their right of freedom of speech by attending the conference, their right under Article 11 to join, to have a peaceful assembly, although of course the protesters could also claim that theirs was peaceful assembly, albeit lying down in the middle of the road. Take that up in the next video. Bye for now. Bye.